All right, welcome. Let me get my camera back on. I am recording this class. If we do get disconnected for those watching live, just stay on the line. Hopefully I've resolved those technical issues, but I'll try to get back on or use my backup device. Today, welcome. We're gonna proceed with our third, it's our fourth class, but it's in this course, but it's our third lab, which I am now devoting to the law of ideas. Let me though, before again, let me just make a couple of announcements. Next Tuesday, I'll have a special session, completely optional, at 5 o'clock, which I will also record via Zoom, where I will go over the guidelines for the final project. And then I'll post that recording to web courses. I've also posted the guidelines. If you want to take a quick look at them, I've posted them a week early so that students can get started. The main thing is start thinking about who you want to work in a group. I just want to say at this stage, I am requiring the final project is a group project because of the format of this course, which is supposed to emphasize group activities. But I think after the initial legwork of forming a group, actually, I think that works to everyone's advantage in that you can divvy up the work for the group as well. So again, I'll do a special session for the guidelines to review the guidelines for the final project next Tuesday. That's going to be November 1st at 5 p.m. And so I'll post an announcement to web courses. Today, though, in this lab, it's devoted to the lab to the law of ideas. I think it's the most important of our modules in terms of it, if our focus is why do startups succeed and most fail, and the key here is product or service that succeeds or fails embodies a set of ideas. And the key is going to be, does the company own the rights to its ideas? So for this purpose, I want to, I'll be going back. I'll talk a little bit about Google and Apple, Coca-Cola, companies that, famous companies that own valuable intellectual property. But I will focus a lot on the founding of Facebook and talk a little bit about the social network and the allegation that Mark Zuckerberg stole the idea of some classmates. So with that, and here's what we'll do. Let's go ahead and check out the survey results. I have posted a link to the survey. Might as well just get that out of the way. And we'll see what the tentative results, as I just posted the survey earlier today. Then what I'll do is I've been using the survey results to lecture about whatever law we're discussing in the relevant module. Today though, I'll try something else. I'll try, after we do the survey results, I'll go over those quickly. I'll do a mini lecture so I can emphasize some important ideas. So let's jump in here. And what I'm going to do is a screen share in order to pull up the survey. So let me go ahead and do that. Now I have posted a link to the survey in the chat. Also, if you go to modules, it'll be one of the assignments at the bottom of the module D, which is the module for this class. So let's go ahead and now that I have it ready, pull this up. All right, I think we're now on the course homepage. What I will do is just jump into the modules, and you're going to see there's a lot of interesting material in the module, which is designed to supplement the chapter 24 in the assigned textbook, which is a nice overview of intellectual property, what I call the law of ideas. So here I already have module D open, and I have a little primer here as well. Shorter than the chapter, but has a lot of the relevant information. And then I have some bonus materials relating to the founding of Facebook. I also have a couple of other examples of intellectual property, but let's jump in here into our survey and check out these results. We find survey statistics. because this is such a large class, we have 5 sections, it's taking a little while to load. Let me see. Oh, there it is. All right. All right, we'll let this load, and I want to get a sense of what the class thinks about the various aspects of intellectual property. And my first question is if anybody owns or has created intellectual property. Generally speaking, when you create intellectual property, the creator is the owner. We'll see this with trademarks. We'll see this with copyright and trade secrets. A lot of times, though, intellectual property is licensed so that the creator will license the rights to his or her intellectual property to another entity, to another person. So here, let's just see what the, and by the way, how here, this is what we'll be talking about today, the main forms of IP. I'll say more about each of these areas in the mini lecture. What's interesting here is this is one of the few survey questions that almost everyone gets wrong. In fact, I want to make it abundantly clear that every single student in the class has created and owns intellectual property. I don't have my phone here, but every time you take a picture on your phone or a selfie, if you've written, a poem or a love letter or an essay for this course, a doodle, anything that you've written down, created, is technically your intellectual property. Now, whether it's valuable or not, right? Maybe it, is it part of a business plan? That's what we'll look at in more detail. But everybody has created intellectual property, and so we'll talk about the 4 main forms. Maybe not everybody, for example, has patented an invention, but maybe you have a recipe, that could be considered a trade secret. We'll see what the requirements are. Maybe you don't have a brand per se, that you own the trademark rights to, but like I said, if you've written a poem, taken a picture, you own the copyright to that creation. So the next question is Google's PageRank algorithm. How does Google protect, that probably single most valuable piece of intellectual property? And what's interesting here, we have a 60-40 split. I'll show you Google's original patent, but in fact, Google also uses trade secret law to protect a lot of the subsequent innovations it has made to its PageRank algorithm. So I'll compare and contrast sort of the pros and cons of patent law and trade secret law. Let's see here, our next question. Did Zuckerberg steal the idea for the Facebook? Did he infringe intellectual property rights? And let's see what the class thinks here. Only 37% say yes. The majority say no. This is going to be really interesting. This is going to be part of the mini lecture. While there's no doubt that Zuckerberg stole the idea, as we saw with contracts, for example, there's not an overlap between law and morality, a perfect overlap. Not all promises are legally enforceable, and not all ideas are necessarily protected. But we'll see which ideas are protected and what needs to be done to allege someone has stolen your idea. So we'll delve into that scenario a little bit more. Has Google become generic? And interesting here, the vast majority say 89% say yes. We'll take a look at a recent case in which this was the key question that the court grappled with. My next to last question here is, can you copyright a tattoo? So we'll take a look at copyrights. This is actually the discussion post question for this module. And interestingly here, only 37% say you can copyright a tattoo. I will tell you, this is an open legal question that has not yet been decided by the Supreme Court of the United States. So I'll give you the arguments for and against. It's actually a very close question. So I'll do that in the mini lecture as well. And then finally, I ask, you may have heard of the Napster case. This was a peer-to-peer file sharing system where Napster users basically could share their music files. The court said that is, if you do that without authorization, that is technically copyright infringement. So I asked, well, what about YouTube? Let's see what the class thinks about here. Interestingly, have a wide variety of answers. I'm going to come back to that survey question and explain directly why it is YouTube, unlike Napster, hasn't run afoul of potential copyright infringement liability issues. Very, very important in that every company has an internet presence. Some companies like YouTube and Napster, the ability to share files is the basis of their model. So I'll end the mini lecture on that note. All right, so without further ado, what I'm going to do is, we've seen now some of our tentative survey results. Let's go ahead, and I say tentative because we have 5 other sections, and so we'll see as the results come in. I can tell you, based on my experience, although I've reworded and edited and included some new questions, but these results pretty much conform to what I generally see. So what I'll do here is, let me screen share my presentation of my mini lecture, just to make the lecture a little bit more interesting, not as boring, just me talking. I'll go ahead then and do that screen share. I'm just pulling it up now, and then I'll go into the screen share modality here. All right, here we go. All right, now we have a lot of ground to cover. Intellectual property, it's so important. So I'm going to cover the most important aspects of ideas with reference going back to our survey questions. So let's go ahead and do, hold on here. Let me go ahead and do a, let's see here, the slideshow presentation, make this a little bit more attractive. All right. Great. Let me go ahead and expand this here. Okay, perfect. So let's talk about the law of ideas. This is important because, a business cannot succeed unless unless it's offering a product or service that people are willing to buy. Or in the case of the internet model, where you give your stuff out for free, people would be willing to use, and then you can monetize those users to sell ads. So that's why the law of ideas is so important, because here's the key. It's not enough to have a good idea. You have to find a way of being able to say that I own the idea. Now, this may sound familiar because we talked about Pearson v. Post and the ownership of a wild fox. And we saw that there could be in our previous module and on the common law. And we saw that the law could often prefer a bright line rule or a general standard in determining, how do we determine somebody owns something, especially when there's multiple claimants saying that they're the creator, they're the owner. The Facebook case is just a great example of that. So let's just jump in and let's begin with, before we talk about Facebook, let's talk about what I think is the single most important valuable idea. And that is going to be this, the Google PageRank algorithm that was patented, or at least the application for the patent was submitted, and you'll see it here. It was filed on January 9th, 1998 by none other than Larry Page, a PageRank algorithm that he further developed with a fellow Stanford classmate, Sergey Brin. Notice the ownership of the patent right here was assigned to Stanford University. This is sort of an important footnote. This is the work for hire doctrine. When you work for somebody, right, anything you create really belongs to your employer, unless you have a contract in place specifying that no, the creator retains his or her ownership rights. Now, in the case of Stanford, and UCF does this as well through our Office of Research and Commercial Technology and Commercialization, when Larry Page and Sergey Brin graduated, Stanford gave them the patent, gave them back their patent in exchange for a royalty deal. And each of these transactions are individually negotiated. In a way, you could say it's a win-win. Larry Page and Sergey Brin now can start their own company, and that company will own this very valuable patent. And at the same time, Stanford wins because now they've negotiated a deal with these two startup founders that if their company succeeds, right, they're gonna benefit as well, as as was the case. But here's the deal to get a patent. Here's the thing to get a patent. It's very difficult because the requirements for a patent are, and by the way, go into the textbook, there's, different types of patent. Here I'm talking about what lawyers call utility patents, what you normally think about when you think of a patent, which is an idea for a new invention or a process for building a new product or internet interface or whatever. Your invention has to be new, useful, and here's the difficult element: non-obvious. What that means, technically speaking, is that your idea, based on the existing state of scientific knowledge, nobody else, it was non-obvious. Nobody else could have discovered it. Think about it. This is very hard to prove because, Larry Page came up with the PageRank algorithm, which was a new way. And by the way, the technical details are fascinating. How the PageRank algorithm, Google search, how the subtle differences between Google search, for example, and previous search engines of the day, like Yahoo, and today we have Bing. I think Alta Vista was a big one back in the day. I think AOL had a primitive search engine. I won't go into the specific details, but proving something is non-obvious can be really difficult because you basically have to say that given the existing state of scientific knowledge, my invention is not only new and useful, but nobody else would have come up with it. And that's hard to prove because somebody did come up with it, right? The person who's filing the patent registration, patent application. Now, let me show you one more thing to show you like how this cashes out in practice. Look at the date this patent was granted compared to the date that it was filed. Literally it took almost 4 years, 3 years and 6 months and 25 days to be exact, if you're counting, for probably the single most valuable, commercially valuable idea to receive a patent. That's how difficult and slow, and you can imagine then how expensive the patent process is. And the reason for that is because it's how do you explain to the United States Patent and Trademark Office that your idea is in fact not just new and useful, but also non-obvious? And this is why, by the way, those of you who voted that Google uses trade secrets, we're also correct. Because while Google does have a lot of patents, I attended earlier this month, I attended a talk by Google's chief economist, Hal Varian, and he said that just in the 2000s alone, after Google got that initial patent, Google has now 60,000 patents that they've either developed themselves or they bought the rights to. But a lot of the innovations Google also protects via trade secret law. And one of the cool things about trade secret law is that, and I have an example here, probably the most famous example, right? The Coca-Cola formula. Although I'm holding a bottle of Coke Zero as I drank the last Mexican Coke we have, so I'm borrowing my daughter's Coke Zero bottle. But the Coca-Cola formula or the Coke Zero, right, are very famous examples. A lot of successful products. Think of like traditional products like the Louisiana hot sauce, Tabasco. Think of that. That's a recipe, right? That is a trade secret. Also, going back to Google, a lot of these innovations that they've done to Google that we use today, Google has decided to go the trade secret route. And one of the advantages of the trade secret route is there's no filing. There's no filing requirement. So go back to Google's patent. Look at the date that it was filed. Patents, and you learn this in the textbook, patents have an expiration date. Patents are legal monopolies, that the owner of the patent, right, has a legal monopoly over his or her invention. But that monopoly expires after 20 years. The Google patent for PageRank algorithm has now expired. It's now in the public domain. And so that's probably why Bing and other search engines, DuckDuckGo, probably use some form of the PageRank algorithm, a way of weighting relevancy based on the number of other web pages that link to the page being ranked. I won't go into, again, all the technical details, but it's a very, probabilistic and sophisticated method of conducting search. But notice here, right, this patent expired. So you can already see right off the bat, there's a huge advantage of maybe going the trade secret route, because with a trade secret, which is pure common law, there's no federal state registration at all. With a trade secret route, as long as I have a commercially valuable idea and take reasonable steps to keep my idea a secret, there's no registration. And so there's no expiration of my trade secret. So this leads me to the second major topic, and this was the third question on the survey. Did Mark Zuckerberg infringe the intellectual property rights? Did he steal the idea for Facebook? Interestingly, a little more than a third of the class would say yes. A majority would say no. And here, what's interesting is, let's take a closer look at this. There is one, if you will, everything has a trade-off. So we saw one advantage of trade secret, right? There's no filing requirement, so there's no expense and this kind of stuff of, having to go to the trademark patent office and trying to prove your idea is non-obvious. Also, you have the advantage that there's no expiration date, right? Like the Coca-Cola formula, the Coca-Cola bottle I showed you, but reverse engineering is a defense to an allegation of trade secret theft. And so, Zuckerberg could always argue, no, I came up, is what he does, right? The Jesse Eisenberg in the movie. No, I came up with the idea for Facebook myself, is what his idea is. Personally, I find that completely hard to believe, because he was working on the other social network site called Harvard Connection, so that, did he reverse engineer or did he steal the idea? Let me see if I have this here. Well, let's look at the definition, common law definition of misappropriation or theft. And what's really interesting is defined very broadly. Unless, if you're accused of stealing someone's idea, trade secret theft, unless you can allege reverse engineering, notice how broadly theft is defined. It includes not only improper acquisition, right? That's the theory of the Winklevoss twins. You basically agreed to work with us to steal our idea and then create your own website. And maybe if that wasn't your initial intention, at some point in time, that's exactly what you did, right? That's the Winklevoss's theory of their case. Improper use, that would be that second scenario, that even if you began with good intentions, you used our source code without our consent, or notice this third way of theft of a trade secret, which is just improper disclosure to a third party, even if you don't use the trade secret, or even if you didn't acquire it illegally, but if you share it with somebody else who doesn't have permission to, access it, then that's also considered trade secret theft. So to the extent Zuckerberg talked about any of the technical aspects of the, Harvard Connection Winklevoss website with any of his partners like Eduardo Saverin or Dustin Moskovitz, who came on board a little bit later, there's actually a very strong case to say that he committed theft. And this is probably why, by the way, in real life, this case settled out of court, because there's, it basically comes down to is, did Zuckerberg reverse engineer, which is perfectly fine. If you can figure out on your own, how to make the Coca-Cola formula, that's perfectly legal, By the way, this is why, and I'm sorry for the reflection there. This is why, even if you could steal the Coca-Cola formula, or you figure out, reverse engineer it, which is perfectly legal. Notice, right, Coca-Cola owns the trademark to its logo, right? So that you wouldn't be able to use. You'd have to come up with your own branding. So let's talk about that. Let's talk about branding. And the key thing about a trademark is that it's got to be distinct, or what lawyers call secondary meaning. When customers see your mark, your logo, your brand, they think of your products. Now, the textbook goes into a lot of detail how, your mark can be either arbitrary or fanciful. Think of Kodak, think of Google itself, right? Very fanciful. word to describe search engine. Think of Apple, right? Arbitrary, right? Using the word Apple and the Apple logo to describe, computer products, MacBooks and iPods and Apple Watches and iPads, right? Completely fanciful. You also have suggestive marks, descriptive marks, and generic marks, which are not protected. One of the interesting things, so you can't use you can't take a word from the dictionary. You can't, you can't use that as your own trademark, for example. This controversy, I have a video on it, the Taco Tuesday. Unless customers, consumers associate your mark, Taco Tuesday, with a specific company, or a specific type of taco, it's open for everybody to use. But sometimes, like Google, right? There's an allegation that Google has now become generic because we just use the word Google to refer to internet search, whether we're using the Google search engine or not, right? Probably we are going to be using the Google search engine, but not necessarily. Well, here there's an interesting case. When I revised the textbook, I included this case. So you want more information about the case, it's in the textbook, chapter 24, where this allegation was made. Somebody was registering domain names with the word Google in it. And then Google, of course, got wind of this, and then they sued for trademark infringement. And the guy who was using the word Google in all of his domain names, I had no relationship with Google. He was just, basically, if you will, free riding off the famous Google trademark. What the question was, right? The defense was, well, no, Google's now generic. Everybody uses it sort of just to refer to internet search. What's interesting, though, this case, it was decided a couple of years ago, I believe end of 2019, beginning of right before the pandemic. And the court there said that, I believe incorrectly, by the way, I agree with the class. I think Google now is a generic term, but the court there said, no, Google is still a distinct mark. So maybe the next case, when it comes around, maybe Google will lose that case. By the way, this is why trademark law is so important, because even if Google does become generic, right, and anybody can use the word Google, the Google logo, and I don't have it here. I thought I had it here as my next slide, but you all know what that Google logo looks like. That look, itself, nobody else would be able to copy, right? We'll look at copyright law in a moment. I do want to say one word about registration of trademarks and copyrights, which will be our last topic. And that is, with both copyrights and trademarks, it's like trade secrets. No registration is required. And so that's why you'll often see a TM instead of an R with the circle. The R with the circle means that the trademark has been registered with the United States Patent and Trademark Office. The TM means no, it's an unregistered common law trademark. But the main difference is that with registration, this is true for copyrights as well, with the registration acts as dispositive proof of who the owner of that IP is. So registration has that advantage that is just considered dispositive proof that, to use the Pearson v. Post analogy we saw in the common law module, you grab the fox first, it's yours. It's a bright line rule, So registration has that advantage. Registration has another advantage that's less obvious, but really important to lawyers. And that is, with federal registration, now the owner of the intellectual property has the ability to go into a federal court to enforce his or her IP rights. You now have federal jurisdiction. And this is kind of important because trade secrets are common law. There's no registration. There's no federal overarching law dealing with trade secrets. And so with trade secrets, you have to go into, unless some special circumstances exist that we'll see in our next module when we look at diversity jurisdiction. Generally, with trade secrets, you have to go to state court to defend your trade secrets. Interestingly enough, the Zucker, and we'll see this actually in the next module. We just don't have enough time today, but we'll look at the Winklevoss twins initially sue Mark Zuckerberg for fraud, breach of contract, unjust enrichment, and also trade secret theft. But they sue him in a federal court using this special exception. So I'll talk about that, when you can sue in federal court, even when your claim is based on state law. But the reason why this is an advantage is that federal courts, generally speaking, this is on average, right? Federal judges are much more stricter with deadlines. And so cases, if you're suing somebody, you generally prefer federal court because jury verdicts are larger on average, and cases go to trial more quickly on average. This could be a question of degree. Still going to federal court, as we'll see in the next module, can take still many years and stuff like that. But generally speaking, it's quicker, and you might be entitled to a greater amount of damages just the way historically the federal courts have evolved. So I'll say more about the state and federal court system and bringing a case and all that stuff in that next module 2 weeks from today. All right, the next to last survey question we had was, can you copyright a tattoo? And what I love about this particular, and I use the Mike Tyson example, just because Mike Tyson has what is to me my favorite quote of all time: everybody has a plan until they get punched in the mouth. This is a great quote because, just think of the business world, right? Blockbuster was this huge giant chain, and they got punched in the mouth, right, when Netflix came out. Now you could say Netflix is getting punched in the mouth with Hulu and Disney Plus and Paramount Plus, et cetera, right? And all these other alternative competitors, streaming services. As we'll see when we talk about Napster, the record industry got punched in the mouth when Napster came on the scene and basically made music free for everybody. So we could go on and on. BlackBerry, the BlackBerry. I used to have a BlackBerry myself, but now that is obsolete. Once the iPhone came, all of these companies, were successful companies, but they didn't. The lesson here, right, is they didn't adapt and change their plan when they got, metaphorically at least, punched in the mouth. Also, if I may, you permit me a digression or a footnote here. This is just good advice, I think, in one's personal life, because we're always going to suffer setbacks, unfortunately, whether it be in relationships, whether it be, at work, whether it be family strife, we're often, life is really tough, and we're going to face setbacks. And what Mike Tyson is really saying here is that you should expect that, and then you have to rise up to the occasion and change your plans, change your ideas, update with the times so you can respond and survive and thrive. And I think that's really good advice. But going to the specific question, can you copyright a tattoo? Why is this still an open question? Because with copyrights, remember I said everybody here has created intellectual property? I was really referring to, copyrights. Look, anything that you can write down, or publish is quote unquote copyrightable, just to put it squarely like that, These are just some examples, even dance choreography. If you have an idea for a new dance, you could technically copyright that, and you've seen these controversies about the Fortnite dance and stuff like that. The Happy Birthday song at one point was under copyright protection, anything, the way the law is worded, and this is all based on common law, but the federal law allows you to register your copyright if it's commercially valuable, right? You may want to do that. And the idea is that as long as your work is original, you're the first one to come up with it, and you can publish it or affix it to what's called a tangible medium of expression. It looks like tattoos would qualify, right? As long as the tattoo, you're not just copying somebody else's design, and you could, actually, copy a tattoo design, right? You could put it on a t-shirt or on a piece of paper, right? But there's one major exception to copyrights, and that is fashion designs. So for example, like I'm wearing, I took my tie off today since we're talking about intellectual property rights, I'm talking about startups and new ideas and creativity. So the idea is, anybody can market and manufacture and sell a dress shirt, right? But that's an example. That's why, fashion designs are not quote unquote copyrightable. So what you'll normally see is, as I'm wearing this shirt my wife gave me, the Brooks Brothers logo. So what you normally see is like the Polo Ralph Lauren logo, or if you have jeans, the Levi's logo or Sevens logo. You'll see that anybody can make a pair of jeans or a shirt, but it's the logo that's going to be trademarked. But going back to copyright, um, um, everything except basically fashion designs, is a very important exception. And so this raises the question, right? What is a tattoo? Is it more like a fashion design or a fashion accessory, right? Because it is on your body, just like when you wear clothes, right? Or is a tattoo more like a work of art? You know what I mean? Picasso painting or something like that. You can see there are good arguments on both sides. And the cases that have posed this question, including the case involving Mike Tyson's tattoo, have all been settled out of court, or are still pending litigation. And so, until this gets up to the U.S. Supreme Court, or until Congress, for example, steps in and clarifies, whether tattoos are more like art or more like fashion designs, we won't have a specific answer to that question. All right. The last question I asked about was, well, YouTube, right? Why is YouTube in business, whereas Napster got shut down? And so here, what I want to do is, I have some bonus slides, and we do have now time to address this. So I want to talk a little bit about the Napster case. What's really interesting about the Napster case is that, Metallica was one of the first bands, musicians, and Dr. Dre as well. They sued Napster for copyright infringement because they discovered that a lot of their music, which wasn't yet available, commercially available at record stores, back in the day, they would, music industry made most of its sales via CD sales. In fact, I have a graphic. I'll come back to fair use. You can see that the peak of the sales of CDs was right when Napster was. It could be a coincidence, right? Or it could be there's some causal relationship here. Napster comes out, music is now available for free. Boom, CD sales plummet, as you can see from this chart. Napster's defense was fair use. And here's what I want you to know about fair use is that it's 4 factors. It's a general standard. It's 4 factors. These are all, according to courts, equally important. It's kind of a subjective, but I like to use the example of myself. I in my presentations and in my YouTube videos, I'm using a lot of sources that I just get off the internet. Notice that while educational use or parody and that kind of stuff is purpose of the use, while that is one of the factors, it's just one of the factors, right? There's these other factors you have to look at. And I would, just to cut to the chase, I would let, courts give a lot of importance to this last factor, market effect. Basically, is your use of someone else's copyright, of someone else's intellectual property, is it expanding the market for, for the underlying work that's being here used without authorization? Or is it in fact siphoning off sales from, that authorized, owner of the copyright? And so the interesting, and by the way, when you apply this to Napster, right? You could argue this is a coincidence. Certainly Napster, they hired some economists, but I have to say, it looks pretty bad for them, and they did end up losing their case. The fair use defense was rejected in their case, but this still leaves the question of YouTube, right? So I'm gonna do just stop the share and explain the main difference between YouTube and Napster, because really, in many respects, right, YouTube is the same as Napster, but instead of MP3 files, right, people are sharing MP4 video files, right, not just audio files, but video files as well. One of the great ironies of YouTube as compared to Napster is that now Metallica, for example, has its own official YouTube channel. So that same song, they sued over, the Mission Impossible 2 theme song, you can just freely listen to it on YouTube. So what happened in the interim? Well, there's two big differences. One is going to be more business and the other is legal. I'll talk about the business one difference first. Napster, right, refused to negotiate at all with Metallica and with Dr. Dre, and then with the Recording, Industry Association of America that brought a global lawsuit on behalf of all songwriters and musicians that belong to that trade group. And so, Napster basically said, sue us, we'll see you in court, and we'll take our chances with the fair use defense. By the way, what's really interesting with the fair use defense, right? Well, I'll say this at the very end, because that's a larger point I want to make at the end. But going back to Napster, right? The difference is that YouTube, right? If you have a certain number, the more subscribers you have on YouTube, and the more views your videos have on YouTube, right? YouTube actually shares its revenues with YouTube channel creators. So Metallica is actually getting part of YouTube's profits, right? So there's a business relationship there. Now, I don't know what the details are, I'm sure Metallica and YouTube have a good deal that's fair to both sides, right? YouTube gets to host Metallica, so they're going to get all the Metallica fans now are going to go on YouTube, right, to listen to the music, or watch the videos, and then Metallica is then going to get a share of that revenue that YouTube is getting, that advertising revenue. But the other reason is, remember, Metallica here is the copyright owner. They don't have to make a deal with YouTube if they don't want. That's the benefit of being a property rights owner. You decide what you get to do with your property rights. And so, and this is where, in that last slide I showed you, the DMCA, the Digital Millennium Copyright Act. I want to end on that note because it's really important because it affects all of us, since we're all using the internet, and if you will, assuming it's fair use, borrowing stuff from the internet, or if it's not fair use, we're stealing stuff from the internet. Now, what the DMCA does that's so important is a law enacted in 1998, where Congress made the decision that copyright law does extend to the internet. This was a momentous policy decision when Congress enacted this law, which was signed in, and this bill was signed into law by President Clinton back in 1998. The reason why is because, you will be too young to remember, unless you're as old as me, but the internet was supposed to be this libertarian paradise where there would be no sales taxes, no intellectual property rights. It would be a completely, truly free environment, but today we do pay sales taxes, that's gone. And, copyright law does, and by analogy, intellectual property law extends to cyberspace. But what the DMCA does is it strikes an interesting compromise. I would consider it a compromise because in order for a copyright owner, whether it's a movie studio or a record label or a publishing house, in order to enforce your copyrights on the internet, you first have to send what's called a takedown notice to the person who's infringing on your copyrights, right, who's posting your stuff on the internet without authorization, and to the platform where that stuff is being posted. So to the YouTube user who posted without authorization, maybe a video clip that's copyrighted, and to YouTube itself. And here's the difference between YouTube and Napster, right? YouTube will comply with the takedown notice, right? They won't even ask the YouTube user. They will take down the material. You see this a lot, for example, if you like Prince's music, right? The Prince's estate, very strict about their music copyrights. And so it's very hard to find, Prince stuff on YouTube. Because they do, rather than having an authorized Prince channel the way Metallica does, and then sharing the revenue with YouTube, they just rather control the rights and not allow anybody to use it without authorization. So that is, now I consider this a compromise because think about what this means in practice. You're a publishing house in New York City, or you're a Hollywood movie studio or a record label. Now it's up to you to hire a bunch of people or a bunch of software developers to create algorithms to scour the internet, all those YouTube channels and all the other sites on the internet to detect, Facebook and all those other places, to detect infringing uses of your copyrights, And even after you've done that, you're going to have to hire a lawyer or someone with some professional, legal experience to send the takedown notice, right, to the user and to the platform, and it's also a compromise because if the user and the platform or either one takes down the material within a reasonable time, that is considered a safe harbor. You are immune from copyright infringement liability. So it's a big, a protection. Now, if you receive a takedown notice or a platform receives a takedown notice, they also have the option of doing what Napster did, and that is, okay, we're going to fight it in court. We allege fair use, and we'll take you to court. But if you go to court, then the court will have to apply those 4 factors. And because those 4 factors, it can be hard to predict how the court is going to, rule on each of the factors, right? It can be hard to predict the outcome of a case asserting the fair use defense. So it's kind of like we'll talk more about litigation and, why cases settle versus going to trial in that next module. But I want to let you know now. The other thing I want to say that's really important about the fair use doctrine is it's not obvious. It's one of the reasons, but it's one of the reasons why I don't use the word, and I actually abhor the use of the word, copyright pirate or intellectual property pirate, because in fact, although intellectual property rights, intellectual property law are designed to protect ideas through patents and trade secrets, or the expression of ideas through copyright law, or brands through trademark law, guess what? The law also attempts to strike a balance between owners and people, if you want to call them, thieves, I call them borrowers, people who want to take those ideas and do something different. Think about copyright law. We just saw the fair use doctrine, fair use doctrine says, you're allowed to quote unquote steal, to use works without authorization, even though they're copyrighted, if you can fall under the, if you can persuade a court that the fair use factors, work in your favor. But even trade secret law, right? Reverse engineering is allowed, right? Patents, the invention has to be non-obvious before it receives protection. And trademarks, the mark has to be distinct, arbitrary, fanciful, suggestive, or have some kind of secondary meaning where consumers associate your trademark with your brand, with your products and services. And so that's an important example. And my bonus slides, I have the example of the Facebook like symbol. Can you trademark or copyright a like symbol? Well, yeah, you can copyright it if it's, if the design is exclusive to you, you know what I mean? If it's an original design, and you can also mark it, get trademark protection if, consumers associate your particular thumbs up design with your service or your products. And in fact, Facebook does have a trademark on its particular like button and the other emojis that has come up with subsequent. So that's why this area of law is so important, because it allows existing business firms and entrepreneurs as well, startups, to assert ownership rights over their ideas or the expression or branding of their ideas. And think about it, right? Every successful product, every successful business, every successful product or service embodies a set of ideas. So that's why this area of law is so, really, to me, it's the single most important area of law. And it's why I like to play Fat Joe, because not only the 2004 song, corresponds to when the Facebook was launched, but, hip hop culture, right? It's about becoming wealthy and successful. But in the business world, if you want to be wealthy and successful, you really have to have valuable intellectual property. You have to have good ideas, right? And what intellectual property law allows you to do, the law of ideas, whether it's through trademarks, copyrights, patents, or trade secrets, it allows you to do just that. Assert your exclusive ownership rights over either your ideas themselves, whether it be a trade secret or a patent, a non-obvious invention, or the expression of your ideas via copyright or the brand, your logo, distinct markers of your products and services. So that's why this area of law is so important. All right, with this, we now conclude this part of the law of ideas. And so what I'm going to do here is stop the recording and just keep it open for any questions, comments, or concerns about any aspect of the course. Let's see here.